Good morning, everybody. Thank you so much for joining us today. I'm so glad to have you here. My name is Sarah Ann Ellis. I am the manager of programming at TMA, and I'm excited to have you here for the How to Protect Your Business from Sales Commissions Dispute webinar. I want to say a special shout out to Kristen and Christina for bringing this topic to TMA, as it is so important to share with our members. Without further ado, I want to let you know this webinar is being recorded and will be shared after the webinar completes. But with that, Kristen and Christina, I would like to throw it over to you to get off on the webinar.
Great. Well, thank you, Sarah Ann. I think we'll start just by introducing ourselves. On our first slide, we have a beautiful photo of Kristen, and she can introduce herself to all of you.
Hi, I'm Kristen Shields. I'm currently president and on the board of Graymills Corporation. It's my family business, and we've been in business for over 85 years, and throughout that have used independent sales reps exclusively. And that's what I'm here to talk about today.
And I'm Christina Carriere Lutz. I'm a commercial litigation partner at the law firm of Gozdecki, Giugice, Americus, and Brocato. Say that 5 times fast. It's a mouthful. And I have worked with Kristen on sales commission disputes. I've been practicing for about 16, 17 years. And if you're not familiar with commercial litigation, that is everything in the nature of a business dispute. It could be a breach of contract action, breach of fiduciary duty claim. It could be a partnership dispute, and it falls. It kind of covers the issues of sales commission disputes. We, Kristen and I, kind of got together and talked about doing this webinar as a bit of a cautionary tale, so that she could share a little bit of her experiences with TMA members to help protect people from the kinds of claims that her business has had to encounter. You can't prevent someone from suing you, but you certainly can take as many steps as possible to deter those kinds of lawsuits and to protect yourself so that you have a positive outcome in the event that they do occur, because there are always these types of disputes. So what we wanted to do is just talk a little bit about what the Illinois Sales Representative Act is, how it works, and how you can protect your business. In a perfect world, when you're bringing someone on as a sales representative and you're planning on paying them either partly in commission or entirely on commission, everybody would hire a lawyer and draft a legally enforceable agreement, like the 17-page one that Kristen now has, to protect themselves against any potential disputes with the sales rep down the road. But in the real world, the reality is people do not always operate that way. There is a real concern about the cost of hiring counsel for these kinds of agreements, or it seems like it's very straightforward, and so people don't think it's necessary. There are any number of reasons. It could be because the sales representative arrangement is so old. Maybe somebody's been with the company since, there were predecessors that were running it. But in any event, what I encounter all the time is agreements that are done by handshakes, agreements that are done by a series of emails where it's here's the commission rate and here are the accounts that you'll get commission on, and that's the contract. Or, sometimes the best case scenario is that the principals sit down, somebody from the company and the sales rep, and they hammer out maybe a 2-page agreement. This is very normal, but if you're me and it comes time for there to be, a termination of the sales representative, it's like I cringe, because it can really open the company up to so much liability if things are not properly documented. So, even with a written agreement, it may not cover everything it needs to, and you can't, like I said, fully prevent someone from suing you. But our goal is to help you learn about this act and how to minimize your risk in dealing with these commission sales reps. And, of course, I have to preface all this by saying that this is for educational purposes. It shouldn't be construed as legal advice, but if anyone needs to talk about a specific situation, I'm more than happy to do that offline. So I think let's start by just talking a little bit about what the Sales Rep Act is, and then we can get into some of the issues that Kristen encountered in the real world with it. So there are laws in a number of different states that are specifically designed to protect sales representatives because the legislature deems them to be in a weaker position than a company in terms of their respective bargaining power. So the idea is that this act was created to ensure that post-termination, the sales representative will get paid so that people aren't trying to get rid of someone who should be collecting commission in order to not pay them commission. So the act requires that a sales representative be paid in full on all commissions due that they have earned within 13 days of termination, or the company can be liable for 3 times the amount of commissions owed. We call that treble damages, as well as the attorney's fees that the sales representative incurs if they sue in order to collect those commissions. The Sales Rep Act only applies in certain circumstances. So it does not apply to employees. Everybody probably has an HR person or an HR department that knows all about what to do when you terminate an employee. This is not that. That falls under the Illinois Wage Payment and Collection Act. This applies to outside sales representatives that you have a separate contract with who are not employees. It can be a person or it can be a company, but it is not for employees. So if you signed on to this webinar thinking that we were going to talk about employment law, you can feel free to busy yourself with something else, because this is its own unique animal. But part of why we want to talk about this is that people are not aware of how the Sales Rep Act works. They do have those HR departments who are very well versed in what to do with employees, but they are not familiar with this other agreement. They're thinking, or with this other act, they're thinking, I have this contract. This is just straight contract law. It's not. It's a different hybrid thing, and you really have to know about it in order to be able to protect yourself. So it doesn't apply to sales representatives who sell services. It only applies to sales representatives who sell goods. That I'm guessing falls under the umbrella of just about everybody who would be interested in this from TMA. So Kristen was involved in, is still unfortunately involved in litigation in California. And I came in because I have quite a bit of experience in this area in Illinois. With the Illinois Sales Representative Act, if anyone is involved in litigating a cause of action under the Illinois Sales Representative Act, they will come across, there's a very small body of case law on the subject. And one of those cases that went up on appeal, went on for many years, is now kind of the law of the land on this topic, is a case that I litigated. So because of that, I became sort of, an expert in the field. I've litigated a ton of these cases, and I had the pleasure of working with Kristen's attorneys in California and kind of advising them on some of the issues with the Illinois Sales Representative Act. So Kristen, maybe you can talk a little bit about, without getting into anything kind of attorney-client privileged about the case, can you speak a little bit about what you knew about the Sales Rep Act before this lawsuit?
Honestly, we didn't know it existed. The rep agreements that we had were done. The last time they had been signed was in 2014, but I think somebody just copied and pasted something that had been done in years prior. I don't know that we ever talked to an attorney about it. It was not, that was something that the creation of those documents I was not involved in. And those documents consisted of three very separate things that were signed at a sales meeting in June of 2014. It was a rep agreement, which was a very simple, few bullet point rep agreement that mostly dealt with commission. The second one was a rep expectation agreement, which just was our, if you want to be a sales rep, this is what we expect of you. And the third was our confidentiality, non-disclosure agreement, which we use the standard one that we use in other areas in our business. The first two documents did not have any reference to any disputes. There was a very clear, either side can terminate in 30 days. And within that 30, they get 30 days of orders. And if any outstanding quotes are entered in that 30-day period, they get paid for that when those orders ship out the door. So those first two documents had nothing in them about, how to resolve a dispute at all. The NDA confidentiality agreement was very specific about disputes going to arbitration in Cook County, Illinois. So we terminate this rep in California. He had been a sales rep for probably close to 50 years. Wasn't performing, and we also found out he was selling competitive equipment to ours. So we would send a quote and the customer would buy part of the stuff from us and part of the stuff from our rep there was a lot of nefarious stuff going on there. So terminated him, there were lots of back and forths about the orders and the quotes and that. And our system turns over to the new people out in California. And that was April of 2020. September of 2021, we got served with a lawsuit from a plaintiff attorney in California for a lot. It was, trying to think, was it well into the seven figures for commission, and it went way back. This is a long drawn out tale, but anyways, the crux of not being able to get a summary judgment or a dismissal of the case was that we failed to pay the rep about $3,000 there was a multi-release order. And you all that are manufacturers understand that there was a multi-release order. The last part of that multi-release shipped in Q4 of 2020. And when the people responsible for commissions did it, they totally missed paying him the commission. He never came back to us and asked for that commission either. They just kind of slapped us with this lawsuit. So they hung their hat on the fact that we didn't pay that amount and therefore we couldn't make the suit go away. The biggest complication was they filed the suit in Superior Court of Los Angeles County, but they wanted to import the Illinois Sales Rep Act as and Christina helped me with the legal language, the governing
law.
The governing law. So they didn't file federal court. They didn't file in Illinois. They filed in California and wanted to use Illinois law in California. So round and round and round, it took 2 years and two different judges, and the judge had a preliminary ruling in California not to use Illinois law. And then about 6 weeks later, when he made his final ruling, he did a complete 180 and said that he would allow Illinois law to be used. So that just threw a ringer in the whole thing. And it became not about paying his client, which was, $3,000. It became about this excessive inflated plaintiff attorney bill. So we did end up settling last spring with the sales rep. We are still in court battling a almost $1 million plaintiff attorney fee. And so we have Zoom court Thursday, actually, in California to see where that goes. But in the meantime, I had to then spend money on experts to go through their legal bills to say that number that they put in there was inflated by about 10 times. So it gets very costly very quickly.
And even at a tenth of the, $1 million that they're seeking, we're still talking about a $3,000 underpayment that they're trying to collect, this massive attorney fee bill as a result of under the Illinois Sales Representative Act, because the Sales Representative Act says, I mean, the plain language is that if you do not pay, you can owe triple damages. That's considered a penalty. So there has to be some egregious circumstance to make it 3 times the damages. Typically, it's 1 time the damage, but these plaintiffs' attorneys always ask for 3 times damages because that's what the statute allows for. And they get fees. So one of the things that is very tricky about these claims is that, as Kristen is dealing with now, often the bill for attorney's fees is as big, if not bigger, than the claim for commissions. And this plaintiff's firm that is handling this in California, this is their business model. They bring a lot of these kinds of sales representative claims just for the purposes of getting fees on them. And so this is really why we wanted to talk about this. Of course, under Illinois law, attorney's fees have to be reasonable. And so that's something that, Kristen's lawyers will be arguing about in court this week, fingers crossed. But it is so disappointing in a way to see that an act that's intended to protect the sales representatives can have, such a chilling effect on who they were doing business with as a result of these very inflated attorney's fees bills. And so this is a big reason why it's so important to take steps to protect the company at the outset, because even if you're thinking, well, the commissions probably wouldn't be that big on a claim if I did get sued one day, this is really why we're talking about this. Because
and we didn't even talk about my attorney's fees. My attorney's fees are probably close to $1 million defending the case. And if this doesn't if the importation of Illinois law doesn't get overturned somehow in the process of trying to deal with these attorney's fees, that then sets precedent. And Christina, again, you're the lawyer, sets precedent for opening this up all over, that any plaintiff attorney can figure out how to, because the Illinois law is, for somebody to consider an Illinois law to be more beneficial than a California law, it's a gold mine for the plaintiff attorney.
Yeah. And, there are these sales rep acts all over the country. Each one is different, and it creates a lot of ambiguity and uncertainty for the companies because if you don't have any kind of law specified in your agreement, or in your circumstance, Kristen, where you had these different agreements and they kind of tried to take the law from one of them and apply it to another one, then you can't be sure what's going to happen and you're leaving it up to the court. And so really this is about taking back control so that you have some certainty in what will happen, so that you're not leaving it up to a judge in whatever state the lawsuit might get filed in. So, let's get into it a little bit, because there are a lot of just very concrete basic steps that you can take to protect yourself. And that's really what I want us to have a chance to talk about. Just kind of big picture, who has to comply with the Sales Rep Act? It's any individual or company that manufactures, produces, imports, or distributes a product for sale, contracts with the sales rep to solicit orders for the product, and compensates the sales rep either in whole or in part by commission. So that's, that probably applies to a large number of TMA members. So how do you comply with the Sales Rep Act? Sorry, my phone is ringing. Let me just turn it off. How do you apply with the Sales Rep Act at the beginning of the relationship? the ideal start to a sales rep relationship is you put the contract in writing. And don't worry if you haven't, or if you have a writing and it's not great, we'll talk about what to do about that too. But what you want to make sure that you're including are things like how commissions are earned. So when people do these email back and forth or these very short contracts, they don't always address how sales commissions are earned. And that frequently results in claims where the sales rep will say that they're owed commissions on sales made to various customers, that that's not who the company thought that they were going to be having to pay commission on. The rep might have done very little or nothing at all to service that account. But you see, once you get into litigation, the way that, the expectations expand from the plaintiff's perspective. So to avoid this situation, if you make sure that you put in writing how a sales commission is earned. So for example, is it when an order is placed by a new customer? Is it when orders are placed by certain existing customers? And if so, you want to specify them. Is it when an existing customer orders a new part or product, for example? What about multi-release orders? How are commissions going to be treated on those? When an existing customer increases beyond a certain amount of orders, is that when a commission is earned? Do they earn the commission when the purchase order is placed or when the customer pays the purchase order? These are all things that you want to think about and make sure that you have documented, because this is exactly what we end up fighting about for years if you get sued, and it gets very costly. So it'll help just save you a lot of money in the long run. Of course, all of this kind of depends on your business model, and it's typically unique from company to company. But these are just considerations that you want to go over when you're deciding to enter into a new relationship. You want to also address the duration, the renewal, and the termination. So all of this is how long does the agreement last and when can you end it? So this is an interesting topic because if your contract doesn't specify a sufficiently definite duration, then it's deemed terminable at will under Illinois law. I have had more cases about sales representative commission disputes involving the duration of the contract than any other topic, believe it or not, because sales reps think that if they have sold in this relationship and they have set this business up so that you're profiting off of this relationship that they introduced, that even once you terminate the agreement, they want to continue to see those commissions forever. And they don't think that it's fair if you try to cut off paying their commission. So inevitably, we have a lot of fights over how long does this agreement last. So you want to be very clear at the outset of the relationship to say that the sales representative is not entitled to commissions on any orders that come in after termination. Because if you don't, then the laws are very favorable to sales representatives and they might fill in the blanks in a way that you didn't intend for them to.
And Christina, that actually happened in part of it with us, that they tried to do that.
Yes, this is a very common claim. So something that you want to talk about, and I'm jumping ahead here, is addressing commissions on reorders. So there's a cause of action called a procuring cause claim, which is even if the contract is terminated, if the sales representative is deemed to have been the procuring cause of a sale prior to termination, then courts still say that they are entitled to earn that commission. However, you can contract around procuring cause claims. So you can say upon termination, they are not eligible for any further commissions. They only get paid on purchase orders received during the course of the agreement, or they only get paid on purchase orders paid during the course of the agreement. They will not be paid on reorders of product after termination. They will, you can be very specific about all of this in order to make sure that those claims down the road are foreclosed. So you can, put it in your agreement that they shall not be entitled to any commissions on sales made post termination. No further fee will be due to the contractor on orders or reorders. So we really, this is why Kristen's agreement is 17 pages long now. I have gone through so many of these claims that, there is a way to draft around every possible issue. It's just you have to really give it a lot of thought and know this area of law well. Dispute resolution is a really big one, and that's one that Kristen now has in her agreements that I think is hugely valuable. So one of the things that we see in these claims is a lot of times these sales reps have been working for decades for the same company. And that means we're talking decades worth of discovery. Now, some things might be beyond the statute of limitations, but even in Illinois, the statute of limitations on a breach of contract action is 10 years. So the cost of going back through 10 years worth of purchase orders and, payment records and sales reports and commission reports and emails with this sales rep is extraordinarily expensive. It is massively time consuming. It's a huge drain on people's business. And it leaves open the possibility that after you terminate the sales rep, they will say, hey, remember that time 4 years ago when we were having a hard time getting that deal done and I agreed to cut my commission in order to make it happen? But we had a contract that said I was entitled to 4% and you only paid me 2%. So I think I should get that other 2% on all of those sales going back 8 years. This kind of thing happens all the time. And if you put in your contract a vehicle for the sales representative to dispute whatever commission they're paid, and you say, and you make sure that they have the documentation to know whether or not they would have a claim. So they get the copies of the sales reports, the commission reports, whatever it is that they need to determine if you paid them properly. You can put in your contract, you have 30 days to contest any commission payment, or you will be deemed to have agreed that you were paid the proper amount. Now, depending on the circumstances, they fight this too. They'll fight everything, but it is a huge protective measure to make sure that you're not stuck going back, a whole decade looking at every single transaction. There are a lot of other things that you want to put in these contracts too. Like Kristen was talking about, venue and choice of law. These things can be very impactful depending on, if you think that you have one state's law that's going to apply that doesn't have the Illinois Sales Representative Act and these triple damages and attorney's fees, and then you find out that you're stuck with Illinois law. That can be surprising. So it gives you certainty. It gives you an opportunity, preferably to talk with your lawyer about what state's law you should be choosing. You can have provisions for how to treat confidential information. I see the question, does this mean companies should have a document retention set at 10 years? So you do not have to have a 10-year document retention policy. However, if you have, and we're going to talk about this in a little bit in terms of best practices during the course of the agreement, there are ways to maintain certain documents that will be beneficial to you. So you don't have to keep documents going back 10 years, especially when it comes to email. If, for example, your company has a 5-year document retention policy, you do not want to have to go through 10 years of emails. I mean, it is Kristen's, like, I can see on your face, she's like remembering how expensive that is. My colleague Tim, who is kindly running the slides for me right now, is an expert in e-discovery. Law firms have, people who oversee these massive projects of collecting documents and producing them in the course of lawsuits. It is unbelievably expensive. So you don't want to have to go through that process, but there can be documents that are helpful for you to keep. And so we'll talk about that. Just moving on to our next slide. So this is best practices for during the relationship, right? How do you comply with the Illinois Sales Rep Act so that if you do get sued, you're in a better position? You want to keep accurate data. Keeping good data is one of the best ways that you can protect yourself. And by keeping good data, I mean run sales commission reports. Make sure you have copies of purchase orders that you are calculating commission percentages off of. And I recommend keeping it together with the commission report. So have the commission report and have the backup for the commission report and store it somewhere that it's easily accessible. So what I always recommend is have a file for each sales rep, and in that file, have a designated person who, if it's your accounts payable person or whoever, and whether it's the commission report or a sales report or whatever format it takes at your company, put that in the file, and along with whatever record of payment and the backup purchase orders that support that sales commission report, or invoices, or however it's cataloged. If you have a system where you don't have separate invoices, you have like an interactive interface where the invoices are all pulled from that's fine too. You don't have to separately like print those out and save them into the system, but have some kind of file per person where you can keep very careful track of what you've been paying them all along. Because if you get sued, you have it all in one place. It's a lot easier to collect it that way and organize it as you go than it is to do it many, many years later, looking backwards. That's a very expensive endeavor. You want to give either the sales report or commission report that you are calculating the commission off of to the sales rep, because that supports a claim that they knew what they were being paid and they waived any dispute about being paid that amount because they never said anything for however many years. Courts will look at a pattern and practice of the parties if a contract isn't clear to decide what the contract was. So if you were in the habit of always paying them 2% instead of 4%, and they're claiming, no, I should have gotten 4%, all of that documentation is very helpful. And then if you do have a contract with someone and for some reason you are cutting their commission, that's considered a modification to a contract. This happens a lot. There are reasons why someone's commission rate might change off of what the contract rate was for a specific deal. The best way to handle this is you have to give the sales rep what's called consideration. So legally, consideration is an exchange of something. So I have to get something and you have to get something, and that makes the contract legally binding. If in this context, it can be the sales rep gets $100. you write them a check. They get a little tiny bit of money. And in exchange for that little tiny bit of money, they agree that they're going to take a lower commission rate for particular orders with a particular customer, for example, or particular product with that customer, whatever it might be. You want to make it very clear and document it well. And then that way they can never come back and say, I was supposed to be paid this other percentage, because you now have a new contract with them for that specific product or customer or whatever it is, that they get paid a lower commission rate. So that's, if you were to have a situation where you want to pay a sales rep less, probably want to talk to a lawyer about it, but that is most likely what would happen in order to address that. So on our next slide, we'll talk a little bit about how you comply at the end of the relationship when you're terminating the sales representative, because everyone gets terminated at some point, right? I mean, these agreements don't go on forever. There's always an issue at some point in time in the relationship that, it is extremely rare to not have these terminated. So you want to know before you terminate the person, how long does my contract last? Does it say in the contract how long it lasts? If it doesn't say, it's terminable at will. So that means you can terminate at any time. We talked about how there can be these issues with terminable at will contracts where the sales rep thinks that they're entitled to commissions for forever. A way that I have dealt with that a number of times is to file what's called a declaratory judgment action. That is where we preemptively file a lawsuit. And that sounds crazy, I know, because who wants to be in court? But it's actually very helpful, because if you know that there is going to be a dispute down the line, and you as the company are the one that goes into court first, and a declaratory judgment claim is not a claim for affirmative relief where you're saying they owe me something or I want you to make them give me something, the way that a breach of contract action would be. It's a claim where you're asking the court to give you advice on something so that you don't do something wrong. And as long as you do what the court says, then you're fine. So it's a way to legally protect yourself. So you go in and you say, court, I would like you to declare this contract terminable at will and that I don't owe any further commissions. And then the court reviews the language of the agreement and applies, the law to it and tells you whether or not the contract is terminable at will. It almost always is. If it has no specific duration in Illinois, a contract is terminable at will. The benefit of this is not only then do you have a court order that says it's terminable at will, and so the sales rep knows they're not going to get anything if they try to sue you on it. It also lets you settle any potential claims with the sales representative ahead of time. So before they get that plaintiff's lawyer in that thinks that they're going to make a ton of money off of this cause of action, you have affirmatively gone to court first. You're wearing the white hat as far as the judge is concerned. You're trying to do the right thing. We want to pay him what he's owed. We just don't know exactly how long that is. We think that it is terminable right now and that we don't owe anything else, but we're looking for some protection there. It's a really easy way to open the door to settlements. And once you sign a settlement agreement, you guys mutually release all claims and there's no future liability on these past claims. So it's a very effective way of handling this duration issue that comes up a lot. And then make sure you know when to pay this person and do not pay them late. It is 13 days after the commission was earned, after termination, they must be paid. So that means if the agreement is that they get paid when a PO comes in, make sure they get paid. If it's a multi-release order, make sure they get paid within 13 days on every single one of those. That's obviously something that came up with Kristen that caused a lot of problems. So, in terms of how to fix it, let's see, I see Jeff is asking, can this preemptive action be done with an implied or unwritten contract? Yes, absolutely. An unwritten contract, an oral contract, we would call it, is enforceable in Illinois and in every jurisdiction, just, well, I mean, as long as it's in the sales commission area, just like a written contract is. So you can go into court and ask for a declaration that you don't owe any further commissions after termination on an oral contract, on a handshake agreement. You're welcome. And so if you have an inadequate contract in place, and let's be honest, probably only Kristen has the 17-page document, so there's a decent chance.
And I only have it because
you got sued.
yeah.
Yeah, I mean the likelihood is all of you, have contracts that probably leave something to be desired and that I would redline the heck out of if I got my hands on them, right? So, what can you do about that? All of this is not to scare you. There are ways to address it. So, in order to rectify an inadequate contract, I would get new contracts in place that have all of these terms that we were talking about. And that means you have to look at the existing ones to see what your termination options are. I would give everyone a bonus for signing the new contract or some sort of consideration so that there can be no question as to whether or not it's legally enforceable. Kristen put new contracts into place with all of her sales reps across the board. And it was, a very case by case basis. So it was not an inexpensive endeavor, but I think probably well worth it considering, the past issues that came up based on the previous contracts. So you want to do an audit of the existing contracts, figure out how to terminate them. You can do that and get new contracts in place as long as you give them a small amount of consideration. It's legally binding. And then you want to make sure that you follow these best practices that we talked about during the relationship. And then we talked a little bit about declaratory judgment action to resolve any commission disputes. Mediation is also something that once you file a lawsuit, you can mediate pre-suit. It's hard to get people to agree to that, but certainly once you're involved in litigation, you can try to settle things through mediation if the parties.
And I will add that the California court required us to mediate. We mediated twice. One time for over 12 hours to a point that they turned off the heat in the building and everything, and got absolutely nowhere. And the second mediator said, this should have been settled in a phone call. I don't know why we're all sitting here.
I mean, over $3,000, you would think so.
Yeah.
So I'll pause for a second. I have a couple more things that I'll talk to you guys about just in terms of kind of the litigation side of things very briefly, but I just wanted to check in and see if there are any other questions as I've been going through all of this.
I am not seeing any questions on my end, Christina.
Okay, good. So we've talked a little bit with Kristen's experience about what can happen if you do not comply. And to give you a sense of what the litigation process looks like, not just in this specific situation that Kristen had, but in many of the cases that I've had, the first part of the fight that you have is, what is the contract? So it's, what are the terms of the agreement? How to know if someone did or didn't earn a commission? What are the customers that they're entitled to commissions for? Do they get these commissions on reorders in perpetuity? All of these different questions can take years to litigate, and it's very expensive just to get to a point where you know what the terms of the contract are. I had a case that went on for 5 years and up on appeal and back down, all about what is the contract. Once you're over that hurdle and you know what the terms of the contract are, and sometimes this happens at the same time, you enter the e-discovery process. And that's where we talked about someone who is way smarter than me, like Tim, who knows all about technology, will come and collect email boxes for all of these various, we call them custodians, individuals at your company who had interactions with this sales representative. And you have to go back many, many, many years. Often your customers will get subpoenaed. They will have to produce documents. They will not like this. And so it causes a lot of disruption and expense. Oftentimes you have to use outside vendors. So you end up paying your attorney and the vendor to do all of this. That can be very expensive. And then you have to have people sit through sifting through all of these documents to figure out what actually relates to your particular cause of action. So it is one of the biggest issues that we have in litigation now is how expensive and onerous e-discovery is. And then at the kind of last phase of it, there's the question of how much commission is actually owed. And that's where we get into these issues of whether or not there were any underpayments at any points and were there any changes to the commission rate. Again, that can be a very expensive battle. And then finally, is the sales rep entitled to treble damages? Do they get 3 times the amount that they're owed? If the court deems the company's behavior to be egregious in some way in not paying, then it's very likely they will be able to collect treble damages. And then you fight about the attorney's fees. And throughout this, you're paying your attorneys to do all of this. So it's not an ideal situation. And that's why, in my view, as far as, kind of your risk management hygiene, the Sales Representative Act is as important as complying with any employment law. It's just one that people are very unfamiliar with. So just to sum up really quickly, some takeaways. Take a look at your existing agreements. They probably need to be redone. If you do not have agreements in writing, get them in writing. Keep accurate accounting data and make it available on a routine schedule to your sales reps. You can enter into new agreements, give them a tiny bit of money in exchange. It's well worth it to document the relationship properly. Before you're terminating anyone, probably talk to a lawyer, but carefully review the duration and termination provisions and make sure you're timely paying those commissions after you do terminate. And then if you need help, feel free to call me. I'm happy to do an audit. I regularly kind of go through the existing sales rep agreements that companies have and get new ones into place. And, we try to do it as quickly and painlessly as possible. So if anyone has any questions, I'm happy to stick around and answer and help however I can. And this is my info if anybody needs to contact me, if I've scared the bejesus out of all of you.
And you need to be scared because it was something that we were completely caught off guard by.
Yeah, it can really, unfortunately, especially for closely held family businesses, it can be a make or break the company scenario. And that's pretty terrifying. So, in my mind, even though this might not be, a palatable idea to have to, spend money on attorneys going over contracts and things like that, it's it's something to look at on your agenda for 2025 because it is well worth the investment.
And if you think you have insurance policies to cover it, you don't.
That is an excellent point, Kristen. So I've done a million of these cases. Not one of them was ever covered by insurance. So the companies are coming out of pocket for all of the fees and all of the damages.
Well, ladies, I want to say thank you so much for your time. Christina, I know that you putting this together took some time out of your busy schedule, so I appreciate everything. Kristen, super grateful that you brought this to TMA. I know that this is something that, like you said, not many people really know about, and you didn't know about until you were confronted with this lawsuit. So I hope that we have shed some light for other members that may be, either currently facing this or hopefully never have to face this, because now you have the information at your hand. So ladies, I really appreciate your time for this webinar. I do want to say thank you for everybody who joined us this morning. This link will be shared with you after I receive it to further review in the future, in case you would like to rewatch. I do want to say on behalf of myself and everyone here at TMA, I wish everybody a happy holiday and a great new year. I can't believe that 2024 is coming to a close, and I can't wait to see everybody next year in 2025. Have a great day.
Thank
Bye.
you.